know that it's at the end of the semester. Folks are starting to take off for the holidays, but we're really glad for those of you who are here with us today, as well as the others that are joining us virtually. My name's Angela Gonzales. I'm faculty here at ASU in the School of Social Transformation, and I'm really excited to be able to moderate this lunchtime expert panel looking at threats to tribal sovereignty. We have what I consider in the academic world 3 real rock stars on this panel, and it's really very exciting always to be in kind of like their sphere. We have Dr. Dawn Warne, who's joining us virtually. Dawn is Provost Fellow for Indigenous Health Policy at Johns Hopkins University. We have Rebecca Tsosie from the University of Arizona, where she's Regents Professor and Morris K. Udall Professor of Law. And then I have our ASU colleague here, Trevor Reed, who's Associate Professor of Law at Arizona State University. We're going to start off with Dawn, who's joining us virtually. We will try to maybe save a couple of minutes at the end for Q&A, but just to kind of remind folks, part of the purpose of these panels is really to seed the discussion for the breakout sessions later this afternoon. So if you have questions, which hopefully you do, and don't have a chance to ask it, those breakout sessions would be the opportunity to do so. So Dawn, are you there?
I am. Can you hear me okay?
Great, thanks. Go ahead.
Excellent. Well, very pleased and honored to be here. And full disclosure, I was actually on faculty at the Sandra Day O'Connor College of Law from 2003 to 2007. So great to see Rebecca Tsosie there, one of my longtime friends and colleagues. So I'm so pleased to be a part of this discussion. And also I'm a graduate of Arizona State University with my bachelor's degree back in 1989. So very pleased to be back here even virtually. So as was mentioned, I'm currently at Johns Hopkins University. I serve as both the Provost Fellow for Indigenous Health Policy and co-director of the Center for Indigenous Health. And we'll be looking at issues related to tribal sovereignty, but I wanted to start just with some nomenclature, but also looking at data sovereignty and doing research in Indigenous communities. So we hear the terms American Indian and Native American kind of used interchangeably, but I think it's important that we understand the populations that we're referring to and what the definitions are of those populations. So the racial designation is American Indian and Alaska Native, and that's the indigenous peoples of the US and North America. So the North American US indigenous people are American Indian and Alaska Native, and that's what we use for census self-designation for race and ethnicity. And the reason it's American Indian and Alaska Native is that not all indigenous Alaskans are American Indian. So we do have the Athabascan groups, which are culturally American Indian. Even the Navajo and Apache tribes and some communities, even in California, are Athabascan from cultural perspective. But for example, the Inuit populations are more of a circumpolar indigenous group. So we have Inuit people in Alaska, but also in Siberia and Canada and Greenland. So do not call an Inuit person an American Indian. That's they don't like like that because that's not their real cultural background. So also when we're talking about tribal sovereignty, we have to also acknowledge that enrolled tribal membership is not a racial designation, it's a political designation, much like being a citizen of the United States or a resident of the state of Arizona. An enrolled tribal member really is a subset of the American Indian and Alaska Native population. And if you look at the census, we now have over 9 million self-identified American Indians and Alaska Natives as of the most recent US Census. Now within this, we have the Indian Health Service user population. So when we're looking at data, quite often we look at the IHS data as being synonymous with American Indians and Alaska Natives. And it's important to remember that it's not. The Indian Health Service user population is around 2 million people. And again, that's out of over 9 million self-identified American Indians and Alaska Natives. So the Indian Health Service data set is valuable and necessary, but it is not reflective of all American Indians and Alaska Natives. We need to be cognizant of that. For example, I live in Grand Forks, North Dakota. There are no IHS facilities, so I am not in the IHS database, even though I am American Indian. So just something to keep in mind as we're thinking about data sets and data sovereignty and who controls what types of data sets that we're looking at for research. And again, we look at the term Native American quite often as being synonymous with American Indian, but according to the Native American Programs Act in 1978, Native Americans are defined as American Indians and Alaska Natives, but also the indigenous peoples of Hawaii and other Pacific islands. So American Samoans are Native American, the Chamorro indigenous groups in Guam are Native American. So we can think of American Indian, Alaska Native, or the indigenous US peoples of North America. Native American are all indigenous peoples of US, including the Pacific Islands. So we just need to be cognizant of the terminology that we're using. It is interesting, the reason we're Indians is that Columbus thought he was in India. So since he was lost at sea, I'm an American Indian, we have an Indian Health Service and a Bureau of Indian Affairs. So it's just a fascinating terminology in history. I really appreciate the movement toward using the term indigenous, which is just the original inhabitants of various parts of the earth. And when we look at doing research in indigenous communities, we can also see there's a lot of similarities in terms of health disparities and the impact of colonization on the health of indigenous peoples. So and I really appreciated the previous presentations and looking at this from a global view and recognizing that the pattern of health disparities in Australia, New Zealand, and Canada, for example, are very similar to the pattern of health disparities that we see in the United States. And there has already been good mention and discussion about the impact of colonization, but and also the whole idea of planetary health and land-based healing. I think one of the areas of research that we need to address moving forward is really understanding that long-term intergenerational impact of the loss of land and resources and its impact on the health of our indigenous populations. So in terms of data sovereignty, this is the idea that data are subject to the laws and governance structures within the nation it is collected. And it's important to remember we now have 574 tribal nations within the United States. So something that's unique for tribes and American Indians and Alaska Natives, that we do have tribal sovereignty, which is a unique political status and does give tribes control over their data. However, we have different data sets. So we also have census data, we have CDC data, and we have tribal data. So the tribes control their data, but also when we're working with tribes to conduct research, we have to be cognizant of and respectful of data sovereignty with tribes. So tribal data sovereignty is the right of a tribal nation, to govern the collection, ownership, and application of its own data. And it derives from tribes' inherent right to govern their peoples, land, and resources like any other nation can do. So data and research are not foreign concepts in the indigenous world. We've been conducting research and collecting data for centuries. And I appreciated the discussion on some of the wonderful scholarship that's coming out and looking at indigenous methodologies and research as ceremony and these types of concepts, recognizing that data and research are not foreign concepts. And in truth, we were incredible researchers and experts in the arenas of science. And this quote from Dr. Stephanie Russo-Carroll states that indigenous peoples have always been data creators, data users, and data stewards. Data were and are embedded in indigenous instructional practices and cultural principles. So one consideration when we're working with the National Institutes of Health, and that's the largest funding agency of research in the world, they do want to be able to share data that is collected. So why do they want to share data? One is to advance rigorous and reproducible research. So if we share data across populations, we can enable validation of research results across populations and expand the numbers of communities that are participating in the process of developing evidence-based practices. We can accelerate future research and increase opportunities for collaboration. We can also promote trust in research and more transparency and accountability. And certainly when we think about taxpayer funds for research, we need to show good stewardship of that. So understandably, NIH wants to share data across populations, but we also have to recognize that there are considerations to limit the sharing of data. And I won't go through this entire list. This is available through the NIH. They have a draft policy for data management and data sharing that's available if you're interested in looking in more detail. But there are justifiable ethical, legal, and technical factors for limiting the sharing of data. So perhaps the informed consent process limits the scope of data sharing, or perhaps privacy or safety of research participants could be compromised if the data are shared. But also if there's explicit federal, state, local, or tribal law or regulation that prohibits disclosure or limits data sharing. So we have to be cognizant of the fact that just like states and other laws could limit data sharing, tribes have the right to do this as well. So it's interesting, at least in the research projects that I've been involved with, we have varying levels of understanding of these principles depending on which NIH institute we're working with, or in some cases within the same institute, which program official we're working with in terms of data sharing. So one wonderful thing is that there is a tribal health research office at NIH that's headed by Dr. David Wilson, who's also an Arizona State University alum. So in terms of next steps, we really just need to support tribal data sovereignty and ensure that tribes have more access to data within their own communities. Unfortunately, I've been involved with tribes that have difficulty accessing their own data from the Indian Health Service, or even looking at the tribal epidemiology centers and challenges accessing data. We need to support tribal data sovereignty. And I think these discussions are very important that we're having today, but also recognizing that we need to expand our capacities to collect and analyze data. We need to maximize the use of data sets, particularly data sets that have been corrected for misclassification of American Indians and Alaska Natives, and just modernizing the data infrastructure and support our tribes in doing this. So another idea is tribal research codes and actually having formal adoption of regulation at the tribal level on how research is to be conducted. And I think there's wonderful examples in Arizona with some outstanding tribal IRBs. So I'll just end with this, a couple of images here. Think about the difference between equality and equity. And in the idea of equality, we kind of take a one-size-fits-all approach. So we can think of that as a healthcare system or healthcare services, or we can even think of it as data regulations and data policies. And if we want to achieve equity, we need to acknowledge that one size does not fit all. And when we're working with tribal communities, what we need to focus on to promote equity is understanding that tribal sovereignty is a unique and powerful political consideration. And it's important to have these discussions about threats to tribal sovereignty because we need to promote tribal sovereignty, particularly in the area of data collection and research. So I've been showing this image for years, looking at the difference between equality and equity. And a couple of years ago, someone sent me an image that I think is just brilliant. The question is, why is that fence there in the first place, right? That do we need packages of services and unique policies to overcome barriers, or do we just need to get rid of the barrier? And eventually, what I'd love to see is much more robust research programming going on in tribal nations, but research being conducted not just on the tribes, but actually by the tribes with their own local experts in research process, data collection, and analysis. So I'll go ahead and stop there and hand it over to my esteemed colleagues. Thank you all so much.
Thanks so much, Dr. Warne. We're going to pass it on to Trevor Reed.
Okay. Well, thank you so much. And I want to especially thank Jacob Moore and Angela Gonzales and Nate Wade for all of their work organizing. And also Dr. Warne, thank you for that wonderful presentation, and Professor Tsosie for being here with us and sharing your knowledge. So I'll go ahead and start talking here as the slides are popping up. Intellectual property rights are kind of the subject of what I do. And I'm very interested in working at the intersection of IP and the way that we do research. And so I'm going to talk a little bit about some recent cases involving intellectual property rights and research. I also want to talk about some recent legislation that might be of interest to some of you. Let's see, I'm not sure if my slides have popped up yet.
I think they're working on it behind the scenes.
Okay, all right. Well, before I jump into some of the cases, then I just want to mention and pick up on what Professor Warne, Dr. Warne was saying. We know from the United Nations Declaration that Indigenous peoples have the right to control and develop their cultural expressions, their sciences, their technologies, but they also have the right to develop their own intellectual property systems to govern these materials. We also know, based on the FAIR and the CARE principles that many of you work with for data sovereignty, that Indigenous peoples have the right to access and to govern and to steward their data. And they often do that through intellectual property. We know that currently there are 134 tribal nations that have cultural preservation laws, cultural preservation codes that are written out that anyone can access. 49 of these actually cover data sovereignty. So 49 out of 574, that's actually a growing and really an impressive number. 48 of these actually address intellectual property, and some of them even create intellectual property rights that are specific to the tribal nation, which is a very cool thing. For those of you who are interested, Angela Riley has recently published an article called The Ascension of Tribal Cultural Property Law that kind of catalogs all of these new intellectual property codes and rights that tribes have created. And of course, Professor Tsosie has done incredible work in this space for many years. So it's no wonder then that tribes are asserting these kinds of rights in the partnerships that they're creating with institutions and corporations and other actors in the research space. So I'm going to go ahead and advance this just a little bit. Thank you so much for getting the slides up. All right, so one tribe in particular that's been active on this front is the Tulalip Nation in the Washington State area. Tulalip, its economic development arm, and Stanford entered into a research partnership recently in 2018. And the idea was that perhaps we could use cannabis oil or other kinds of natural substances as treatments for opioid addictions, and also potentially as some sort of a remedy for Alzheimer's disease. So Tulalip actually paid to Stanford $3 million to catalyze this research and move it forward. As part of the deal, Tulalip owned not only its own research material and its confidential information, but it also required the ownership of any data generated by Stanford in the process of conducting the research, right? If we're thinking about data sovereignty, that's a very robust form of data sovereignty. Not only our data, we also own the data that we're sponsoring, the data that's getting created through our money. Tulalip would also own any inventions that were conceived or reduced to practice as a direct result of the research. Well, 3 years later, it turns out that Stanford ended up filing a patent application without Tulalip's knowledge for a synthetic cannabis extract to treat opioid addiction. And so Tulalip alleged in court documents that this was a violation of their agreement, that it should be the owner of any sort of invention that came out of the research data that it owned. So we can see from this case, and now the Stanford and Tulalip are actually negotiating a settlement as we speak, but what we can see here are a handful of interesting things here. The major threat that we see to tribal sovereignty from this case is that some institutions don't believe they have to comply with research agreements or sponsorship agreements with tribes, right? That tribes may not be the owner of patentable material, and that's just plainly not true, right? Tribes are research sponsors, right? And they can own any form of intellectual property and research data, including material that hasn't originated with them. As long as that's part of the agreement, they can claim ownership over that material. And because of that, tribes should be actively monitoring the use of their data, and they should certainly regularly collect and inspect this kind of data. Of course, that means a lot of work for tribes, but as they increasingly claim ownership over this, that requires much more policing, unfortunately. On the other hand, institutions and researchers, what is our responsibility? Well, we need to be more upfront about tribes about the kinds of projects that we're doing in tandem with tribally oriented research. There may be some overlaps that perhaps we should be disclosing, and we should certainly be careful about the kinds of template agreements that we give to tribes, especially in light of data sovereignty principles. We may need to draft entirely new kinds of agreements that account for data sovereignty. All right, let me move on to some recent litigation involving patents. So patents, for those of you that aren't familiar with IP, patents protect inventions that are novel, non-obvious, that are useful, right? And there's been some interesting litigation with tribes who have either invested in research and development, who are creating their own materials, or else that are trying to acquire intellectual property in other ways. In 2017, the company Allergan sold its restasis patent to the St. Regis Mohawk tribe. And the St. Regis Mohawk tribe has actually been acquiring various kinds of patents as investments. Allergan decided to do this in part because it was receiving threats from various generic pharmaceutical companies that claiming that they would challenge the patents that they owned. Claiming they were invalid for various reasons. And so Mylan Pharmaceuticals actually did ultimately bring this action for inter partes review against the St. Regis Mohawk tribe. And the idea was, okay, if we can invalidate the patent, we can go ahead and make this Restasis product without having to get the patent rights. Well, the tribe didn't want to go through that review process, right? It's expensive, there's a lot of expertise required. And so they claimed immunity from suit. And tribes can generally do that. When a private party tries to sue a tribe, usually tribal nations can avoid that suit under the doctrine of sovereign immunity, unless they waive that or unless Congress authorizes the suit in some way. Well, the federal appeals court that heard this case ruled that tribal sovereignty doesn't prevent the patent office from reviewing tribally owned patents. This is a little bit scary for tribes, especially patent owning tribes. That means that they may be hauled into some sort of a proceeding when they either create something new or when they purchase a patent, or even when they enter into a research partnership with an institution. So what does that mean? Well, on the ground, it means that tribes have to prepare for potential patent litigation when they get into this space, unfortunately. They should perhaps also have heightened standards now for novelty and non-obviousness. When they go out and sponsor a project at a university, they need to be more careful, perhaps, and set these higher benchmarks. For universities and researchers, there's perhaps a need for us to think about alternatives to patent protection, maybe trade secret protection, maybe adopting tribes' own intellectual property frameworks, right? So this case is potentially a little bit disturbing for us. On the bright side, though, we've seen some interesting advances in the protections for culture and creativity through copyright law. For those of you that do social science research, copyright law can be an interesting tool and also an interesting challenge for those of you who do interviews or perhaps gather various kinds of media. Copyright protects culture generally, especially creative expressions of authors that are written down or recorded. So the good news here is that in two cases that have recently settled, corporations have recognized tribes' copyright interests in their work. So the first one that you see up here, the retailer Neiman Marcus appropriated or allegedly appropriated this raven's tail coat by Alaska Native artist Clarissa Rizal. And in doing so, violated potentially her copyright. So the Rizal estate, Sea Alaska Heritage Institute, sued Neiman Marcus for copyright infringement and a few other claims. The case ultimately settled, and as part of the settlement, Neiman Marcus had to make restitution under Tlingit tribal law, which was really interesting. A second case, Mad Happy, the fashion retailer out of LA, had appropriated or allegedly appropriated the Navajo Nation seal, which is a copyrighted work, if you can imagine that. Navajo Nation sent a cease and desist letter, and ultimately Mad Happy agreed to turn over the profits from the sweatshirts to Navajo Nation and also require its employees to undergo cultural sensitivity training. So what do we learn from these? Well, what's important, I think, is that tribes are making much stronger inroads to protecting culture. For researchers, that means that we need to be much more cautious in terms of the kinds of waivers, releases, informed consent. All of these need to be much more robust and recognize the copyright interests or other intellectual property interests Native creators and culture bearers have in these materials. Okay, now, that copyright law certainly covers a lot of things, but there's also a lot of stuff in institutions' collections. And that's been the concern of many Indigenous communities. How do we get this material back? Copyright law could be a tool to use in this space. And I can certainly talk about copyright law later on. But what I want to point out here is that a recent piece of legislation, the Music Modernization Act, has actually made it both easier and harder for tribes to protect and reclaim these kinds of materials, especially these historic sound recordings like oral histories or music recordings. So let me explain in a minute here what that looks like. So it used to be that these kinds of historic recordings were only protected under state or possibly tribal law. They weren't protected under our federal copyright laws. In fact, there's a big carve out in federal copyright law that lets states and tribes kind of call the shots. Well, in 2018, Congress passed a new piece of legislation that allows these kinds of state or perhaps even tribally created rights to be covered under federal enforcement. So now you can go to a federal court and sue somebody for copyright infringement if they take one of these historic sound recordings and exploit it without your permission. That's great news, right? Because federal copyright law gives you all kinds of tools, including you can sue somebody for up to $150,000 per instance of infringement, right? So that could be a hefty deterrent. The problem is it also includes some exceptions and exclusions. And the biggest one is this one, and I'll end with this. Congress introduced something called the non-commercial use safe harbor. Basically means anyone can use a copyright eligible historic sound recording for a non-commercial purpose without permission of the copyright owner, as long as they go through these 4 steps. So first they have to do a reasonable search, which means for Native American materials, they go to the tribe and ask them if the work is being commercially exploited. Then they file a public notice with the Copyright Office. And then if after 90 days, nobody opposes the use, they have a safe harbor against any kind of infringement claim going forward for that particular use. That's a little scary for tribes, right? They've been trying for decades to try to own and manage these materials. And all of a sudden, Congress has opened up a door where their recordings can now be exploited through this pathway. And it's hard to know whether tribes will have the ability to actually opt out of these things. Anyway, these are just a couple of the threats, and I'll go ahead and end there, but I'm happy to answer questions later on in the Q&A or breakout.
Great. Thank you, Trevor. Yeah, and then we pull it up. They were having trouble hearing it. How much?
Good afternoon. I am so honored and pleased to be here. I was at ASU for 22 years. It always feels like I'm coming home. Thank you so much, Jacob, for organizing this conference. Your team is amazing. You've done a wonderful job. And on our panel, Angela, it's great to see you again. Thank you for moderating. Trevor, thank you for your words. And Dr. Warne did a wonderful job teaching for us in the Indian legal program. That's when we were back at the Tempe campus, and it was a wonderful time. So I just want to greet all of my colleagues from ASU and U of A. It's good to see everybody working together. And I know Myra Parker is there in Seattle. So hi to Myra. So I have about 10 minutes to talk about threats from the United States Supreme Court. That is not enough time to talk about the United States Supreme Court. So I'm going to give you just a little snapshot. And what I want to say, and we've had wonderful people speaking today about tribal sovereignty in all different dimensions. You're so fortunate to hear from Attorney General. He is absolutely amazing. Fred Urbina has been a force, and he gave a wonderful template of what contact to now has looked like for Native people. One of them is the fiction of the law. So the doctrine of discovery was really that these lands were not settled by civilized people. Why weren't they civilized? They weren't Christian, and they didn't have a rule of law. And that has been one of the biggest things to counter. That's why, for example, my colleague Stephanie Rainey can do presentations where people say, well, is sovereignty too political to get into it? It's no more political than the United States asserting its rights in the United Nations, okay? That's what governments do. They assert sovereignty. But sovereignty for Native people, as you've heard all day, is both political and cultural. This search to define what inherent sovereignty is, that's the federal Indian law mythology. Inherent sovereignty is cultural sovereignty. It's the law that has always been grounded in place in the people. Those norms and values, what you just talked about, Trevor, and what you write about, that is Indigenous law, and it exists throughout the nations of Indigenous peoples on every continent, and it is rooted in every land. And to keep hold of that is the only thing that can stave off the threats from the Supreme Court, because what the Supreme Court does, and it is a master at doing this, is it takes this version of political sovereignty. The federally recognized tribal governments have political sovereignty, and that is very, very important. But under federal Indian law, it is encompassed within a federal power structure. So the idea is that American Indian and Alaska Native nations are domestic dependent sovereigns. That means the federal government has plenary power. Congress can enact statutes either taking away tribal sovereignty, or in some cases, they even delegate federal sovereignty to tribes to exercise extraterritorial jurisdiction. But on their lands and territories, that political sovereignty is firm over territory and membership. So the Supreme Court gets engaged in that, and it has developed a doctrine of when tribal sovereignty is implicitly divested. That means Congress didn't act and the tribe didn't give it away in a treaty, but the Supreme Court thinks that it is inconsistent with their dependent status. And when Attorney General Urbina talked about Oliphant, the case that said there's no tribal jurisdiction, criminal jurisdiction over non-Indians, that isn't rooted in any statute. That is a finding of the United States Supreme Court designed to protect the liberty interests of non-Indians. So the way that I'm going to frame the threat from the Supreme Court, to the extent that we can see it emerging from this very, very new court, and anything can happen. I don't think any of us were ready for the last term. Anything can happen in the Supreme Court, but these are things to think about as we look at what they're doing with tribal sovereignty. Number one, let's go back to that question of criminal jurisdiction in Indian country that Attorney General Urbina mentioned. And you remember the historic McGirt decision from 2020, in which 5-4 in the U.S. Supreme Court, but Justice Gorsuch said the Muskogee Creek Reservation was never disestablished in Oklahoma. So what did that mean? It meant that an Indian who murdered another Indian within the territory of the Muskogee Creek Nation, treaty territory, even though it looked like Tulsa, Oklahoma, it was the territory of the Muskogee Creek Nation that was under federal jurisdiction under the Major Crimes Act and under tribal jurisdiction because it was an Indian crime. Both of those governments can prosecute. There's no double jeopardy. Two separate sovereigns. That was a historic finding about the existence of a reservation in Indian country. Just recently, we got the Castro Huerta decision out of the Supreme Court. Again, 5-4 decision, but this time ordered in the other direction. Justice Kavanaugh writing that in the same territory, when a non-Indian basically was accused of criminal neglect of his Indian stepdaughter, he could be prosecuted by the state of Oklahoma. Why didn't that go to the federal government under Section 1152, which is the General Crimes Act for Indian country? The Supreme Court said, well, they can take jurisdiction if they want to. This is concurrent jurisdiction with the state. That is a first. Every case since the 1800s has held that those federal criminal statutes exclude the state. The Indian country crimes model is distinctive, but he said, no, why? Well, he says Indian reservations are now part of the territory of the state, and Indians are citizens and we can't treat them less than. So this idea of public safety, the state has to take that interest, and the feds can do it if they want to. Did that harm tribal sovereignty? Some people said, oh, what's the harm? Oliphant said that tribe couldn't prosecute the non-Indians, so what's the harm? The harm is it directly engages the protective responsibility of federal power in Indian country. And Indian country is not the state. The second one, the Brackeen case, the Indian Child Welfare Act case. Everybody's waiting to see. That one just got argued in the Supreme Court. And for those of you who, I know everybody is familiar with the Indian Child Welfare Act, and I'm so pleased as Professor Chris Sharp, who was here from the social work program, he said that ASU was one of the very early programs that got involved in that. And I think that that is something to really be proud of, the history of the Indian Child Welfare Act, keeping Native children with their families despite the boarding school era and all of the harms that were caused by removal of Indian children from their families. That is a historic statute, and the trajectory has definitely been to build tribal sovereignty over children and their families. But that was just engaged in the Supreme Court. It was a facial attack, as the Indian Child Welfare Act is unconstitutional. Do you know how rare that is in constitutional law? Almost nobody brings a facial attack. They bring an attack up, maybe on some provision as applied, but not a facial attack. And so the states of Louisiana, Indiana, somebody else, I can't remember, Texas. How could I forget Texas? I think something happened here. Okay, sorry about that, Texas, because the Attorney General was there from Texas. That's right. So they were basically saying this is unconstitutional because if the child is not domiciled on the reservation with their Indian family, if they're domiciled in the state, then it's the state's police power that protects them. And again, that equal protection challenge, that child isn't going to have adequate alternatives for foster care or adoptive placement if you go with those narrow Indian preferences. That is a violation of due process and equal protection. And Congress didn't have the authority to pass the Indian Child Welfare Act. What? Plenary power being challenged? That's also very unusual. But it really, if you look at Justice Thomas's writings, he's basically saying they exceeded their power because this goes to the core of citizens, Indians as citizens within the state, not the Commerce Clause, which protects tribes, tribal nations under federal authority. It's a very slippery argument. I don't know what's going to happen in that case because there were serious standing issues and other constitutional claims that weren't Indian law related. But that gives you an idea that they're now chipping away at congressional plenary power. The final case, which just got accepted on cert, and I just wanted to share with you. I know I'm running short of time, but I'm so excited that we have an opportunity in Arizona for the very first time to ensure that our tribal nations here are represented in the water discussions over the Colorado River and the drought apportionment. There are 2026 guidelines that are forthcoming. This is critically important because tribal water rights are federal reserved rights. They are unlike state use rights under state prior appropriation law, even though they have to be adjudicated. So the Navajo Nation has a case that has been taken up for cert in the Supreme Court, and they actually sued the Department of Interior for its current actions that are going to go into drought contingency planning, which is going to affect a lot of water users in all of the states that are part of that, but certainly in Arizona, this is going to have major impacts, already is having major impacts on municipalities and private state users. So the Navajo Nation is basically asserting we have unquantified rights in the Colorado River, which is absolutely true. And there are many other tribes that do as well. But they brought the lawsuit saying you haven't considered our water rights. And those are essentially property rights. They are federal trust protected property rights. And the Ninth Circuit agreed with that and said that the Department of Interior must consider those as trust assets. That was taken up on cert, and the trust doctrine is another huge mess. So in the Supreme Court, we don't exactly know what's going to happen, but it is very important to pay attention to that. And just in closing, I want to say that self-determination under the UN Declaration is the operative principle that we have to think about. There is a sovereignty model of that. There is a collaborative governance co-management model of that, and that's what is applicable in water because it goes throughout these jurisdictions. And there is a participatory democracy part of that. Every Native person who votes, every Native person who holds a public office or serves on a public board, they are exercising that right of self-determination, even as citizens of this democracy. To hold firm to that, cultural sovereignty and political sovereignty are where we need to be going into the future. Thank you.
Please join me in thanking our panelists. I realize we're out of time, so I'm going to hand it over to Jacob, but thank you all so much for reminding us and also grounding so much of our conversation around tribal sovereignty in very real and tangible ways. So thank you. Jacob?
Thank you, Angela. Thank you to our esteemed colleagues for joining us today. Let's give them a round of applause again for Dr. Warne. So wherever you are.